Citation number 790, the offense of cultivating cannabis. Issue 1. Does the statutory penalty for the offense of cultivating cannabis with the intent to manufacture drugs, as stipulated in Article 12, Paragraph 2 of the Narcotics Hazard Prevention Act, align with the constitutional principle of proportionality in punishment? 2. Does the exclusion of offense under Article 12, Paragraph 2 from the provision for reduced penalty in Article 17, Paragraph 2 of the Narcotics Hazard Prevention Act violate the constitutional guarantee of equal protection under Article 7 of the Constitution? Holding. Article 12, Paragraph 2 of the Narcotics Hazard Prevention Act states, anyone who cultivates cannabis with the intent of manufacturing narcotics shall be sentenced to imprisonment of no less than 5 years and may also be fined up to Nt 5 million, regardless of the severity of the offender's circumstances. A minimum sentence of 5-year imprisonment imposes a heavy deprivation of liberty. For cases where the violation is minor and clearly deserving of leniency, that is, in some circumstances, clearly deserving of leniency, even if the code applies Article 59 of the Criminal Code to reduce the sentence, the minimum penalty still results in imprisonment of no less than 2 years and 6 months. This precludes the consideration of minor culpability, making penalties such as fines or suspended sentences unattainable. This disproportionate punishment results in an imbalance between culpability and punishment. The provision fails to include measures for reducing the penalty or establishing a more appropriate minimum sentence for minor offenses, thereby imposing an undue restriction on personal liberty and security as guaranteed under Article 8 of the Constitution. This restriction violates the principle of proportionality under Article 23 of the Constitution. Relevant authorities are required to amend the legislation in accordance with this interpretation within 1 year of its promulgation. If the amendment is not made within the stipulated time, courts may reduce the statutory minimum penalty by up to half for cases involving minor circumstances. Additionally, the penalty reduction provision in Article 17, Paragraph 2 of the Narcotics Hazard Prevention Act, which excludes offenses under Article 12, Paragraph 2, does not violate the principle of equal protection guaranteed by Article 7 of the Constitution. Recently, the petitioner, the 5th Criminal Division of the Taiwan High Court, Taichung Branch, was adjudicating 108 Xiangsu 495 concerning a defendant charged with violating Article 12, Paragraph 2, hereinafter referred to as Disputed Provision 1 of the Narcotics Hazard Prevention Act, hereinafter referred to as Narcotics Act. The court questioned whether the exclusion of offenses under Disputed Provision 1 from the penalty reduction clause in Article 17, Paragraph 2 of the same Act, hereinafter referred to as Disputed Provision 2, was in conflict with Article 8 and 23 of the Constitution. Accordingly, it ruled to suspend the proceeding and file a petition with the Constitutional Court for interpretation. The petitioner, the Second Criminal Division of Hsinchu District Court was adjudicating 106 Su 94, where the defendant was charged with violating disputed Provision 1. The court raised concern that the exclusion of offenses under disputed Provision 1 from penalty reduction clause in disputed Provision 2 might be in conflict with Article 7 of the Constitution. Therefore, the court ruled to suspend the proceedings and file a petition with the Constitutional Court for interpretation. The petitioner, the Second Criminal Division of Taiwan High Court, was handling 108 Xiangsu 1A61, in which the defendant was charged with violating disputed Provision 1. The court raised the concern that the exclusion of offenses under disputed Provision 1 from penalty reduction provision in disputed Provision 2 might conflict with Article 7 and 23 of the Constitution. As a result, the court decided to suspend the proceeding and file a petition with the Constitutional Court for interpretation. The petitioner, Xian Sang Huang, intended to manufacture the second-grade narcotics drug cannabis for personal use and cultivating cannabis on his home balcony. After the prosecutor filed property charges, the Tainan District Court in 106 Su 725 and the Taiwan High Court Tainan Branch 107 Changsu 408 convicted him. His appeal was subsequently rejected in Supreme Court Criminal Judgment 108 Taishan 1050, which became final. The petitioner contends that the application of disputed Provision 1 in the final judgment, along with the related disputed Provision 2, raised the concern about a potential violation of the proportionality principle under Article 23 and the equal protection guaranteed under Article 7 of the Constitution, and thus request an interpretation. In these cases mentioned above, the judge filed a petition to suspend the litigation proceeding and based on objective ground formed a firm belief that the law was unconstitutional. Consequently, they request a constitutional interpretation from the Constitutional Court. After review, it was determined that this petition met the requirements for judicial requests for constitutional interpretation as outlined in JY Interpretation Number 371, 4572, and 590 by Constitutional Court. Therefore, the petition was accepted. Additionally, the petition filed by individual were found to meet the requirement of Article 5, Paragraph 1, Item 2 of the Judicial Yuan Constitutional Court Procedure Act, and were also accepted. Furthermore, the subject matter of the judicial petition in the cases mentioned above is the same. The subject matter of the petition filed by individual under incurable disputed Provision 1 and 2, which partially overlap with the judicial petition. Therefore, the cases are consolidated for joint review. After examination, the Constitutional Court issued this interpretation with the following reasoning. 1. Regarding disputed Provision 1, the freedom of an individual's body should be protected as explicitly stated in Article 8 of the Constitution. Personal liberty and security are crucial fundamental human rights guaranteed by the Constitution. As the legislative body is allowed to restrict personal freedom through criminal penalties to protect specific and significant legal interests, such restrictions are not prohibited by Constitution. However, criminal penalties are a last resort and a form of a coercive measure. Thus, they must be strictly limited. Refer to Interpretation Number 646, 669, and 775. In particular, the severity of the statutory penalty should be proportionate to the harm caused by the act and the degree of the offender's responsibility, in order to align with the principle of proportionality in punishment under the Constitution, and in order to comply with the proportionality principle in Article 23 of the Constitution. Disputed Provision 1 stipulates any person who cultivates cannabis with the intent of manufacturing narcotics shall be sentenced to imprisonment of no less than 5 years, and may also be fined up to NT 5 million. The purpose of this provision is to prevent action that occur in the preliminary stage of drug manufacturing in order to safeguard the physical and mental health of the citizen. This is an important interest protected by the Constitution. Although cultivating cannabis is a precursor to drug manufacturing, it already poses a certain level of danger to life and bodily integrity. To protect this critical legal interest, the legislative body has adopted criminal penalties with a general deterrent effect, which can be considered as contributing to the achievement of an important public affair goal. Furthermore, since there are no alternative measures equally effective as the criminal penalty, but with a lesser infringement, the use of this penalty is also deemed necessary. However, the term cultivating cannabis in disputed provision 1 encompasses a wide range of situations, from small-scale cultivation to large-scale operation. Given the aim of preventing crime, although the legislature can set higher statutory penalties through special criminal laws, the application of a minimum sentence of 5 years imprisonment, regardless of the severity of the offender's action, makes it difficult for courts to consider the specific degree of harm caused by the violation. For cases with minimal violation, such as growing a very small amount of personal use, even if the court applies Article 59 of the Criminal Code to reduce the sentence, the minimum penalty still results in a prison term of at least 2 years and 6 months. This does not allow for the appropriate consideration of the offender's minimum responsibility, making it difficult to impose alternatives such as fines and or suspended sentences. As such, the punishment may be disproportionate to the offense, potentially constituting an overly harsh penalty and failing to achieve a balance of substantive justice. Disputed Provision 1 does not provide a mechanism for reducing the penalty or offering a more suitable penalty for offenders with minor circumstances. Within this scope, the restriction on the personal freedom guaranteed by Article 8 of the Constitution is incompatible with the principle of proportionality in punishment under the Constitution and violates the proportionality principle in Article 23 of the Constitution. Relevant authorities are required to amend the provision in accordance with this interpretation within 1 year of the publication. If no amendment is made within that time, courts may, for minor cases, reduce the statutory penalty by up to half. Based on this interpretation, for cases that are clearly deserving of leniency, the court may still reduce the sentence still further under Article 59 of the Criminal Code. Regarding disputed Provision 2, the equal protection rights guaranteed by Article 7 of the Constitution do not automatically prohibit any differential treatment. Legislators and relevant authorities, in alignment with the value of the Constitution and the legislative goals, may reasonably differentiate based on the nature of the regulated matter. Whether a regulation complies with the principle of equality should be assessed based on whether the purpose of a differential treatment is constitutional and whether there is a reasonable connection between the classification made and the achievement of the regulatory purpose. Disputed Provision 2 states, those who confess to crime under Article 4 to 8 during the investigation and the trial shall have their sentence reduced. The provision concerns sentence reduction based on the defendant's confession, but does not include confession for crime under disputed Provision 1, leading to differential treatment. However, the determination of which crime and under what circumstances a sentence may be reduced is a matter of criminal policy, and in principle falls within the legislative discretion to form laws. Therefore, if the purpose of the differential treatment established by sentence reduction provision is to pursue legitimate public interest, if there is a reasonable connection between the means employed and the achievement of that purpose, it does not violate the principle of equality. The legislative intent behind disputed Provision 2 is to expedite criminal litigation process for drug manufacturing, trafficking, or transportation cases, encouraging defendants to confess and take the path of rehabilitation. This goal is legitimate. The provisions specify that a defendant's sentence may be reduced if they confess to crimes such as drug manufacturing, trafficking, or transportation under Article 4 of the Narcotics Hazard Prevention Act, possession of a drug with intent to sell under Article 5, using false threats, deception, or other illegal means to make others use drugs under Article 6, inducing others to use drugs under Article 7, or transferring drugs under Article 8. The constituent elements of dispute provision 1 involve the intention to cultivate cannabis for the purpose of manufacturing drugs. The evidence gathering, investigation, and determination of criminal facts for this offense are generally easier than for the crimes specified in Article 4 to 8 of the narcotic cases. As a result, the connection between whether a defendant who commits dispute provision 1 confesses and the prompt resolution of a criminal procedure is relatively weak. Consequently, the legislature, considering factors such as the investigation and trial costs, did not include those who confess to crime under disputed provision 1 in the category eligible for sentence reduction. Instead, it is left to the court's discretion to consider the defendant's post-offense attitude under Article 57 of the Criminal Code. This differential treatment is not inherently unreasonable. In summary, the provision in disputed provision 2 regarding sentence reduction does not include those who committed offenses under disputed provision 1. This does not violate the intent of the equal protection under Article 7 of the Constitution. Part not accepted. The petitioner, the second criminal division of the Taiwan High Court, raised the concern about the constitutionality of Article 17 of the paragraph 1 of the Narcotics Act. However, this provision is not applicable to cases being adjudicated, and therefore, in accordance with the requirement for judicial requests for constitutional interpretation as outlined in our Constitutional Court Interpretation Number 3714572-590. This request does not meet the criteria and will not be accepted.